if you recognize the term likelihood of confusion, then you're obviously not a beginner. And this course is not for beginners, but it's obviously not for experts. A lot of the people who are experts in this area of law, by which I mean trademark infringement, represent plaintiffs. There are lots of people who do both, and there are lots of people who represent lots of defendants. The purpose of this program is to address for the general practitioner, including those who have some familiarity with representing trademark infringement defendants, with approaches that I, in my experience over the years, and with God's help, it has been somewhat successful, to take a very close look at a lot of the things that we take for granted when we get ourselves involved in trademark infringement litigation. I often say that there are three kinds of trademark litigators. There are patent lawyers. I don't think too many patent lawyers are watching this program. They generally consider themselves experts in intellectual property. There are general practitioners who, in our pride as general practitioners, we take the position that there's nothing we can't litigate and there's nothing we won't litigate. And that often works out well. And hopefully, if you're in that category, we will try to get you into the third category, which is the category of people who are general commercial litigators, but who have genuine understanding of what happens in trademark infringement litigation. But the approaches to the problem of understanding trademark claims and recognizing how a large portion of them can be defended against on legal grounds will equip you to handle the process of opposing a preliminary injunction application very well. If you're watching this, chances are you're representing or are anticipating representing a company that's a threat to an existing dominant stakeholder in a market, often in the area of distribution. Trademark is used as a way of preventing so-called unauthorized distribution, which as a general rule is legal. You don't need anyone's permission to sell things that you bought. It's expensive to defend against a trademark claim. The further you go into the litigation, the more expensive it gets. And I'm going to repeat it as the golden rule at the end of the presentation, but I'm going to say it again now so that there's not the slightest chance, if you don't do this work on a regular basis, that you'll forget it when a client calls you up. Your client is not going to get their fees back. There's not going to be an award of fees. It's not going to happen. When it happens, it's newsworthy. When it happens, you hear about it. You don't even hear about it that often. The exceptional case standard under the Lanham Act for when an award of fees is appropriate, which in theory contemplates an award of fees even to a defendant, is virtually non-existent. It doesn't happen. So, two components of trademark infringement. We have to know these by heart. Existence of a valid and protectable trademark and a likelihood of confusion arising from your client's use of that trademark, a likelihood of confusion. So let's unpack that. Let's start with the first component. Your job as a defense lawyer in any litigation, as you know, is to take nothing for granted and to require the plaintiff to build his case brick by brick. So we're going to unpack the first component, which is claimant owns a valid and legally protectable mark. Question number one, is there really a trademark here in the first place? Take a look at the demand letter or the complaint. This is something we can establish on a very quick scan. Not all cease and desist letters come from a lawyer. The best ones, and when I say the best, I mean the best ones for you as the lawyer for the defendant, are the ones that come from the plaintiff himself or someone in his office or someone, even better, his real estate lawyer. Is you don't list every conceivable affirmative defense in a response to a complaint that you get out of a form book. Rather, you focus on the ones that matter and you plead them with specificity as to the facts on which you're basing that affirmative defense. Why do you do that? First of all, that's one of the first questions you're going to get in an interrogatory. It's not going to be a secret. Second of all, you're telling the judge or the clerk when they first read your pleadings that besides deny, 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 you've got a really legitimate, well thought out basis on which to defend against the trademark claim. That's going to, everyone else is doing it. Well, everyone else is doing it, let's be clear. Everyone else is doing it is in and of itself, you know this already, never a defense. Never a defense. Everyone else is doing it. Just like it's not a defense when your dad said you're out too late or you're playing the music too loud, everyone else is doing it is not going to cut it. Everyone else is doing it may be relevant as proof of a lack of enforcement that undermines the secondary meaning claim, or the strength of the mark, which is an issue that we can't go into in great detail here today either. But as standing by itself, third-party infringement is irrelevant. Make sure your client tenders coverage to his carrier if he's got a business general liability insurance policy. If he has been named personally in a lawsuit, his homeowner's insurance should be put on notice. Usually there is not coverage for intentional acts, and many commercial liability policies do not cover intellectual property claims, but you'd be a dum-dum and perhaps guilty of malpractice if you do not recommend that those avenues be pursued and coverage be denied. You're passionate. This client matters a lot to you because this client is an entrepreneur. This client puts its heart and soul into its business that is being attacked. You may be more motivated. You may be even a better lawyer than the lawyer for the plaintiffs. It's entirely conceivable.